Have you ever heard the words, "The police are making a safeguarding referral"? If you have, you probably remember exactly how you felt. Relieved. Because after everything that's happened, it finally feels like somebody believes you. You've called the police more times than you can count. You've kept diaries, taken photographs, saved emails, visited your GP, explained the situation to your children's school. You've told the same story over and over again, hoping that eventually someone will join the dots. Then a police officer tells you they're making a safeguarding referral. It sounds important, and it is. But it also creates one of the biggest misunderstandings in housing law. Many people understandably believe that a safeguarding referral means the council will have to move them. The law is more complicated than that. Let's start with what the referral actually is. When the police make a safeguarding referral, they're sharing information because they've identified concerns that may require other organizations to become involved. That information may be shared with housing services, children's services, adult social care, health professionals, or other agencies, depending on the circumstances. The referral matters. It tells other professionals that the police believe there are safeguarding concerns which deserve attention. But here's the part that's often misunderstood. A safeguarding referral is not by itself a housing decision. The police don't decide who receives a council property. They don't decide whether temporary accommodation should be provided, and they don't decide whether a particular property is suitable. Those decisions belong to the housing authority under housing law. That doesn't reduce the importance of the referral. Quite the opposite. Sometimes it becomes one of the most important documents in the entire case. But it's still one piece of evidence. Think of it as a jigsaw. The police bring one piece. Your GP may bring another. Your child's school may bring another. Mental health services may add another. Support workers may contribute another. And you bring the piece that nobody else can. Your lived experience. The council's job is to look at the picture those pieces create together, not simply one piece on its own. That's why two cases that look similar at first glance can sometimes end with different decisions. The evidence may be different, the risks may be different, the household circumstances may be different, and the legal duties owed in each case may also be different. I know that can feel frustrating, especially if you've spent months or even years living with violence, harassment, or abuse. But understanding how the decision is made puts you in a stronger position than relying on myths. Let's imagine the council accepts that there are genuine safeguarding concerns. Does that automatically mean you'll be offered another council home? Not necessarily. The next question is often about what accommodation the council considers suitable in the circumstances. Sometimes that conversation includes private rented accommodation. For many people, that's a difficult moment. It can feel as though the council hasn't listened. But a private rented offer can sometimes be a lawful way for a council to meet its housing duties. That doesn't mean every private rented offer is suitable. Far from it. The location, your safety, your medical needs, your children's education, your support network, and your family's circumstances may all be relevant when deciding whether that accommodation is suitable. That's why it's important to read the decision carefully, rather than assuming the answer is simply yes or no. If the council explains why it believes an offer is suitable, read those reasons closely. Ask yourself whether they've understood the evidence you've provided. Have they considered the things that matter most in your situation? If you think something important has been overlooked, don't assume the decision is the end of the matter. It may only be the beginning. Many important housing decisions carry a legal right to ask for a formal review. The time limits can be short, and for some decisions, as little as 21 days. So don't leave the decision letter sitting on the kitchen table because you need time to think about it. Read it. Read the reasons carefully. If you don't understand why the council has reached its decision, ask. If you believe important evidence has been misunderstood or overlooked, act promptly. The exact review process depends on the type of housing decision you've received. Keep the envelope or note the date you were notified of the decision, however that decision reached you. Those dates can matter. If you're asking for a review, explain why you believe the decision should be looked at again. Point to the evidence, show how it supports what you're saying. Don't assume the council already knows everything that's happened. Make it as easy as you can for the decision maker to understand your case. And if you're getting advice from a solicitor, housing advisor, or support worker, tell them about any deadlines as soon as possible. Missing a time limit can make putting things right much harder. Now, there's another important point that often causes confusion. Not every housing decision is a homelessness decision. Sometimes the issue isn't whether the council owes a homelessness duty. Sometimes it's about who gets offered social housing through the council's housing register, or whether someone should be moved from one social home to another. Those are different processes. If you're applying for social housing through an allocation scheme, you may hear terms like priority, banding, or reasonable preference. Some decisions also depend on the council's own published housing allocation scheme. That means two people with similar experiences may not always receive the same banding from different councils because each council sets its own published scheme within the law, and those schemes differ. Whatever process you're in, don't let assumptions replace information. Read the letters. Ask questions. Keep copies of what you send. Keep copies of what you receive. And if something doesn't make sense, ask for an explanation before you decide what to do next. The purpose of understanding housing law isn't to win an argument. It's to understand where you stand, what rights you have, and what options are available to you. Let's go back to where we started. A police officer makes a safeguarding referral. That's an important moment. It means concerns have been recognized and information is being shared. For some families, it can become an important part of the evidence that helps explain what they've been living through. But it isn't the end of the process. It's the beginning of another one. A process where the council has to consider the evidence, apply the law, and reach a decision based on the facts of that particular case. Sometimes that decision will be the one you were hoping for. Sometimes it won't. If it isn't, understanding why the decision was made and what you can do next puts you in a far stronger position than relying on rumors, social media posts, or well-meaning advice that doesn't fit your circumstances. Housing law can feel complicated, but the principles don't have to be. Gather your evidence. Read every decision carefully. Know the time limits. Ask questions when you don't understand. And remember that one document, however important it may be, rarely tells the whole story. I'm Arthur, and this is Housing Crisis Guide UK.